Welcome to the 2020 Virtual Civil False Claims Act and Key Time Enforcement Institute, sponsored by the ABA Criminal Justice Section. This session is entitled Developments in Healthcare Fraud. Before I introduce our panel, we would like to take a moment to thank our sponsors. Cohen and Colapinto are our supporting sponsor, and Foley and Lardner LLP, our session sponsor. We gratefully acknowledge our sponsors for the 2020 Virtual Civil False Claims Act and Key Time Enforcement Institute. Thank you for your support. Moderating this session is Lisa Noller. Lisa is a partner at Foley and Lardner LLP in Chicago, Illinois. Lisa, you may proceed with the program.
Thank you very much, Courtney, and good morning to everybody on this, our last day of the ABA False Claims Act conference. My name is Lisa Noller. I am a partner at Foley and Lardner in Chicago, and I'm the chair of our firm's government enforcement, defense, and investigations practice. I represent entities including healthcare providers and individuals who have been accused of or who are being investigated for False Claims Act violations. Prior to joining Foley and Lardner, I was an AUSA in Chicago in both the civil and criminal divisions for 10 years. I'm very, very pleased today to be joined by a panel of experts in the False Claims Act and in particular in healthcare fraud. Alec Alexander, maybe Alec wave to the folks, serves as Deputy Administrator and Director for the Center of Program Integrity. He supports the administrator and all components of CMS in the creation, implementation, and management of federal policy aimed at identifying program vulnerabilities and preventing fraud. Alec also oversees all CMS interactions and collaborations with key stakeholders, including DOJ, HHS, OIG, and other components. Prior to joining CMS, he was in private law practice and also served as an executive in a large hospital system and was an AUSA. Amy Easton, representing the Relators Bar today, is a partner at Phillips and Cohen. She is also a former federal prosecutor. As a senior trial attorney at DOJ, she investigated and prosecuted many significant healthcare fraud cases, including those based on whistleblower key tam lawsuits and cases involving other types of fraud against the government. Her most recent case on behalf of a whistleblower client was a settlement in a key tam that alleged fraud involving FEMA disaster relief funds. DOJ has intervened in that case and it is proceeding. For her whistleblower work, Ms. Easton has been recognized by Law Dragon, which is a really cool entity to recognize anybody, of its 500 leading plaintiff financial lawyers list, and by Washingtonian Magazine as one of its top lawyers in DC. Stacy Race, with the blue background, is a senior assistant attorney general for the Michigan Medicaid Fraud Control Unit in Detroit, Michigan, with over 15 years of experience as a civil litigator. The first half of her career was in the private sector, where she defended civil actions, including those brought against local governments and law enforcement agencies. When she joined the government, she began litigating False Claims Act cases for North Carolina, the United States, and Michigan. Prior to joining the Michigan Mafuku unit in April 2019, she worked as a special deputy general with the North Carolina Medicaid Fraud Control Unit and was a designated special assistant U.S. attorney for the Middle and Eastern districts of North Carolina. She's served on various NEMFUCU teams in and litigation and has been an instructor for several NEMFUCU programs. Brian Roark, representing the Defense Bar, is a partner at Bass, Berry & Sims in Nashville, where he serves as the chair of the firm's Healthcare Fraud Task Force and defends healthcare companies in government investigations and False Claims Act litigation. And last but not least, Natalie Waits is an assistant director for the DOJ Fraud Section Civil Division. She's represented the department in a range of healthcare fraud matters involving pharmaceutical and device companies, opioids, pharmacies, hospices, physician practices, and hospitals. And that is a perfect segue to the topic that we're going to be discussing today, which is developments in healthcare fraud. Courtney, could you please advance the slides? All right. We want to talk a little bit about where we've been, and the past is prologue, right? So it helps us to talk just a little bit about cases and government priorities that have filled the time so far. Courtney, I cannot see the slide deck. Now I can. Okay, government priorities. So as we were preparing for this panel, we were talking about the matters that have really been the focus of DOJ and state FUCUs. Most practitioners know that most QTAM cases and most False Claims Act cases are in the healthcare sector. In fact, last year, greater than 80% of False Claims Act cases were healthcare. And the government's priorities, as we see them, are continue to be Stark and AKS, including actions against speaker programs, copay cases, physician compensation, and since 2018, lab referrals, including the Eliminating Kickbacks and Recovery Act. Opioids, drug pricing, and Part C also continue to be a focus. Next slide. Courtney, can you advance to the next slide, please? All right, I'm going to just continue. Courtney's sending me a note that I can't see the next slide, but that's okay. I'm just going to keep going. Also, people probably recognized a couple of weeks ago that the government put out over 1,000 pages of regulations that propose changes to Stark and AKS, and in particular to the safe harbors. And that will continue to be a government priority because DOJ is pursuing cases regarding both of those statutes. ACRA, since 2018, we also expect to be an area of increased healthcare enforcement because the government's position is that it applies to all labs, not just recovery centers. All of these implicate the False Claims Act. So to illustrate some of the healthcare priorities, we're going to summarize 6 cases, and everybody's going to explain where we go from here. So Courtney, if you could go to the next slide, please. Natalie, can you talk to us a little bit about what the government was getting at with the Novartis case?
Absolutely. Thank you. In July, the department announced 2 settlements with Novartis for more than $640 million, and you see just the headline here. We've included this resolution because it demonstrates 2 areas that I think remain important priorities. And I should also say before I continue with my remarks, although I work for the Department of Justice, I am here presenting my personal views. I'm sure you've heard that disclaimer throughout the ABA conference. But I do think that these areas will remain important priorities for the government going forward. The first settlement for Novartis related to a litigation in which the United States alleged that Novartis hosted tens of thousands of speaker programs and related events under the guise of providing educational content, when in fact the event served as nothing more than a means to provide kickbacks. Novartis paid physicians honoraria, and that was purportedly as compensation for delivering a lecture regarding a Novartis medication. But many of these programs were nothing more than social events held at expensive restaurants with little or no discussion about the actual drug. These events were often frequented by the same group of doctors who would take turns being the speaker, who would speak to the group, and who would, of course, receive honorarium. This case was actually fully litigated and was about to go to trial before the parties reached a handshake. Additionally, I wanted to note, before I talk about the second Novartis resolution, that just a few weeks ago, on November 16th, the HHS Office of Inspector General issued a special fraud alert that highlights the fraud and abuse risks associated with speaker programs. It provides a very detailed list of characteristics that may support a conclusion that an arrangement is suspect under the anti-kickback statute. And I think that this underscores the fact that HHS and DOJ will continue to scrutinize these types of arrangements very closely. The second Novartis settlement related to Novartis's alleged use of 3 foundations as conduits to pay the co-payments of Medicare patients who were taking certain expensive Novartis drugs. For those of you who've been kind of watching the FCA space in the last few years, you will note that the department has brought a number of cases related to similar copay foundation arrangements. And this really underscores the concern that these arrangements effectively seek to circumvent important cost control mechanisms within the Medicare program. And I think the interest in this area will continue.
And Natalie, I think one question that defendants are. Oh. Mine's not working.
And I'm actually going to turn it over, I think, to Amy. So Amy, perhaps even though the slides may be a little slow, maybe you can kick it off.
Sure. Thank you, Natalie. And thank you, Lisa. Thanks for having me here today. I wish it was in person, but a pleasure to be here regardless. The next topic we're going to talk about is physician compensation, which is an issue that DOJ has pursued in the past and is still pursuing. There are quite a few significant settlements on that issue this year, including a large settlement in Oklahoma against a specialty hospital and some providers, as well as this West Virginia hospital we're going to talk about, and others. And I think these types of cases show that paying excessive compensation for referrals can be another way that DOJ believes improperly influences providers' decision-making and can violate Stark, the anti-kickback statute, and the False Claims Act. In the interest of fair disclosure as to this West Virginia case, I represented the whistleblower, who was a former executive. And the government intervened in this case and did an amazing job in a very short period of time. We'll talk about this a little bit later in the panel, but as is happening more often, the judge did not allow very many extensions, and it was a short investigation period. But essentially the allegations here was that there was a scheme put in place by a management company and a CEO who were brought in to essentially do a financial turnaround for Wheeling Hospital. And to get the hospital out of debt and to make it the most prosperous in the region. And the allegations were that one way they did that was by overpaying physicians in order to obtain and to keep their referrals. Now, this is a somewhat common fact pattern in these cases, but essentially there was egregious conduct here as these cases go. And there were some documents in this case that probably make Brian and Lisa and other defense counsel cringe when they see these types of things. But essentially, there were documents talking about we've got to keep these doctors happy. This cardiologist who refers, $10 million or referred $10 million last year, we have to keep him happy. Documents that talked about how much they were paying physicians and what their hours were like, and then saying, but look, we've got to keep in mind, they refer, there's this much downstream revenue last year from this physician. So the kinds of documents that connect the dots are obviously problematic. The other thing about this case was it was not just fair market value issues here, but in certain instances, there were allegations that they were paying doctors based upon the value and the volume of their referrals. So it had both of those issues. This case ended up as an ability to pay case, but still significant and resolved at $50 million. And new management came in and new ownership to take over Wheeling Hospital and fix the issue. Physician compensation, like I said, is an issue that DOJ is active in, and I think you'll see more cases like this in the future.
Thank you. Next slide, please, Courtney.
So on the next slide, we also wanted to reference that clinical and genetic testing labs continue to be a target of DOJ enforcement and related key TAM cases. Other than the Boston Heart settlement that's referenced on the slide, also wanted to reference another settlement from the past year involving Genova Diagnostics, which was in Asheville, North Carolina. Genova was alleged to have been billing Medicare for lab tests that basically just didn't do anything and weren't scientifically proven to aid in patient care. And I wanted to mention that yesterday, Sarah McLean referenced that the government is doing more settlements where the government may agree to a lower amount, but then take the upside in the defendant's business. And if you want to see an example of a settlement like that, you can look at Genova, where the settlement was that Genova agreed to not be paid on $17 million worth of claims that a hold had been put on. But then that beyond that they agreed to pay 13% of their annual net revenue above $100 million and 20% of any asset sales above $1 million. The settlement that's referenced on the slide, the Boston Heart Diagnostics case, a lot of the lab settlements are tied to kickback arrangements. And what was alleged here in two different QTM cases is that the defendant was allegedly paying kickbacks in a variety of forms. One was that they were working with hospitals to set up management service organizations to make payments to physicians that were disguised as investment returns. They were also alleged to be offering free dietitian counseling services to patients in exchange for the physicians of those patients ordering tests from them. And then finally, they were also alleged to be waiving copays and deductibles on commercial health insurance patients in exchange for getting referrals from those patients' physicians. This will continue to be an area of focus, and lab billing is also an area where the government is increasingly using its own data analysis to bring its own cases in addition to cases that relators bring.
Thank you, Brian. Next slide, Courtney. All right, Natalie, tell us about opioids.
Sure. Opioids, as I think many people realize, has been a very significant priority, both civilly and criminally, for the past several years at DOJ. And I don't anticipate a change in that trend anytime soon. In July, as reflected on this slide, the department announced a global resolution with Indivior, which manufactures Suboxone, which is an opioid that is intended to assist individuals addicted to opioids to reduce cravings while going through treatment for opioid use disorder. The $300 million FCA settlement resolved allegations that Indivior promoted its products to prescribers who were writing prescriptions for uses that were not medically indicated, and they also promoted the drugs with false and misleading claims regarding safety. This case in some ways looks similar to many pharmaceutical resolutions that we've reached in other contexts. I think from the opioid perspective, one thing that is interesting to note, in addition to the size of the payment and the guilty plea, is that this is a drug that was used to treat opioid use disorder. I think that we will be seeing kind of additional schemes in the space where people are now seeking treatment and people are taking advantage of the patients who are seeking treatment. So that can be schemes relating to urine drug testing, counseling. There's quite a sort of variety, but I think that in addition to the manufacturers, distributors, dispensers, and prescribers of opioids, we are also going to see schemes related to the treatment thereof. I also should note that in October, the department announced a global resolution with Purdue Pharma and a civil resolution with the Sackler family that owns Purdue for conduct related to the promotion of OxyContin. That case is one of many cases that are involved in the bankruptcy of Purdue. So we anticipate that there'll be kind of continuing interesting developments that come out of that as well. But I know that this has been a very high profile issue for the last several years in the United States. And I do anticipate that there'll be significant focus on it in the department for the next years to come.
And Natalie, just a question for you, if you can answer it. ECRA was passed in 2018, and there hasn't been a lot of government pursuit of ECRA cases. Do you anticipate that will change, and why?
I think it's something that we are still very much considering and evaluating. I I think that we will look at using every tool in our toolbox, but sometimes it takes a little bit of time for us to start seeing the cases either from the relators bar or building them up ourselves before they actually come to fruition.
And Amy, is that something that you feel comfortable speaking to? Is it, or ECRA cases, something you've seen?
It is, it's obviously a tool, it's out there and available. What we look for is what DOJ is pursuing. And so it's pretty early to see that, but certainly something, that in these kinds of lab cases and in certain circumstances, the facts are brought to us by whistleblowers and is something that we can bring to the attention of the government.
All right, thank you. Next slide, please. Stacy, tell us about drug pricing. And I think you might be on mute, Stacy.
And of course, I told myself to turn the mute off, several times before. So I'm glad to be the person to do it, first person to do it on our panel. But I'll just say thank you for inviting me today. I really enjoy talking about issues related to this space, and I'll give the same kind of government acknowledgement that Natalie gave on hers, which is, the statements that I make are my personal opinions based on my work in the field for the last number of years and are not specifically the opinions of the Michigan AG. So having said all of that, let's get into this case. So Mallinckrodt is interesting for a number of reasons. The first of which, of course, is drug pricing, and that's on the slide. That's pretty easy to see. We talk nationally, just in public discourse, about how expensive our healthcare program is. And one of the things that makes it so expensive is the cost of medications. So as we're talking about the types of cases that we're interested in and the types of cases that I anticipate personally that we will be seeing more of, I think drug pricing cases are one of those types of cases. The Mallinckrodt case itself is a case just about one medication. We'll talk about the facts in a second. And just relates to a few years of their failure to pay their full rebate obligation. And yet that alone equates to about $650 million worth of single damages. So as we're talking about the amount of money that is routinely taken from the public fisc in these types of cases, I really think we should be talking more about drug pricing cases because they are so high valued. As I said, this case is interesting for a few reasons, the first of which is drug pricing, but the second is related to the process this case took. So let's talk about the facts of this case. This Mallinckrodt case involves a particular medication called Afcar gel. And this medication came in the market in 1952, but really the story starts in 2007. In 2007, the owner of the product line was a company called Questcor that they later sold it to Mallinckrodt in 2014. But in 2007, Questcor owned the product line. And they did two things that are salient for this discussion. The first of which is they filed for a supplemental use for the treatment of infantile spasms. Between 1952 and the 2000s, they had obtained this medication had a number of different uses. And so in 2007, Questcor sought a separate use, a supplemental use. They later received that. Also in 2007, within the span of just a few months, the company drastically increased the cost of the medication. And this gets back into the drug pricing issue. The medication went from about $1,600 a vial to over $23,000 a vial in just the span of about 3 months. There is a mechanism in the state rebate program that equates the value, that calculates the value of rebate owed by the manufacturer to the state. And one of the metrics that are used to determine that rebate obligation is the cost of the medication. In this case, it was the cost of the medication in 1990. Because the idea is that we want an inflation measure to protect these drastic increases in prices. And because Questcor in 2007 moved the cost of the medication far beyond the cost of inflation, Questcor then had a much greater obligation under its rebate contracts with the states, its rebate agreements with the states. And what happened was Questcor decided that they didn't want to keep paying those heightened rebate obligations. And several years later, they then sought to decrease their rebate obligations, and they used this supplemental approval that they obtained in 2007, 2008 to do so. It was a vehicle that they used to do so. And in fact, in 2013, they stopped paying their full rebate obligations to the states. And it took a little while, but the government ultimately figured out what was going on and demanded that Mallinckrodt pay their full rebate obligation. Again, this was around $650 million. Mallinckrodt, by this point, had already purchased this medication line, Athcar gel, and they bought it, and they weren't going to pay it. And this is what brings us to the next reason why this case is of interest. And that's what happened is Mallinckrodt filed an administrative action in order to have it determined that they didn't owe this additional rebate amount. Certainly didn't owe any back rebates and wouldn't owe any future rebates based on this, based on their significant increase in price per vial from 2007. They lost that. The government fought and won, and they lost that in the administrative. They lost that administrative action. And so now what's happened is that the United States and a variety of states, including Michigan, have intervened in a False Claims Act case in in Massachusetts. So now we're on the chapter 2 of this kind of fight over this particular drug pricing scheme. So the first chapter was the administrative process. Second chapter now is the False Claims Act case. And during the course of this False Claims Act case, Mallinckrodt has filed for bankruptcy. So now we are moving to protect the government interest in bankruptcy. So I'll just note for you that not only is this a drug pricing case, but what we're seeing, what I personally am seeing and what I anticipate we're going to be seeing more of, is the need for the government to work to protect its own interests in a variety of forums, even relating to the same case and the same case facts.
Thank you, Stacy. And Courtney, next slide, please. This is the last slide about where we've been and how it informs where we're going. Natalie, tell us about the Medicare Advantage claims that the government's working on.
Thanks. I think this case underscores, or this area really underscores the point that Stacy just made. Where the government is spending a lot of money, you're often going to see False Claims Act cases. The department has been investigating and litigating a growing number of matters related to Medicare Part C, which is Medicare's managed care program. As many of you know, Medicare beneficiaries can opt out of what we know as traditional Medicare, which is Parts A and B, and instead receive their benefits through private health plans, which are known as Medicare Advantage organizations. And to put this in context, in 2019, 1/3 of all Medicare beneficiaries, approximately 22 million beneficiaries, enrolled in a Medicare Advantage plan. And in 2018, CMS paid more than $233 billion to those plans. So it's a lot of money. And unlike Parts A and B, where Medicare pays for each patient admission or service, under Medicare Part C, CMS will pay a capitated amount for each patient, which is risk adjusted based on the patient's demographic information and health status. Our investigations in the last several years have found that in order to inflate Medicare payments, certain plans or providers have engaged in various schemes to manipulate that risk adjustment process. One type of scheme in particular that we have uncovered has been the attempt by certain plans to manipulate the risk adjustment process by auditing patient medical records to identify additional codes that would increase their reimbursement, but in the process of conducting those audits, when they see diagnoses that would decrease their reimbursement, those are not reported or deleted. They're just simply ignored. So the complaint that was filed against Anthem, which is referenced on this slide, alleges precisely such a scheme. And we've just included this as a recent example of the work that is ongoing in this area. And I fully expect this to be a growing area of our work for the next year and far beyond that as well.
Thank you very much. And Alec, can you talk to us about what the CMS program is planning to do from a non-litigation standpoint relating to all of these healthcare issues that we have talked about so far today?
Sure. Good morning, Lisa. Thank you all to all my co-panelists and to ABA for including me. It's such an honor to be with you guys. Yeah, a couple of thoughts overall. I'm not currently litigating False Claims Act cases, although in my previous life I've done that. I'm honored to serve as the Deputy Administrator of CMS and Director of the Center for Program Integrity. So we're doing a number of other things on the administrative side of the program. But I would add, in terms of priorities, I would add a big category called a case collaboration. I think you should all be aware, and there is no secret that the government's efforts have been markedly increased in terms of making sure that all the levers of government are brought to bear at once and in a collaborated fashion, administratively, civilly, and criminally. That work and that effort continues, and of course, included within that process are the civil fraud section and all the False Claims Act work, including the KETAM body of cases to the extent that they're relevant. So very important. That remains a priority. Much has been done since 2018 in that regard. A lot of the recent success in 2019 around DME and around genetic testing and around opioids in the ARPO cases with the criminal division have stemmed from that work. So very, very important. I would also point out real quickly that and Lisa, I'll just take this opportunity to do this if it's all right with you. On September 30th, there was a follow-on national takedown case around DME. You'll recall in 2019, a number of DME providers, a couple of hundred or so, were taken down for fraudulently billing the program. And this September 30th action asked the next question, which is, where did all the referrals for all of those cases and those companies come from? And as a result of that, there were, I think, 77 or so criminally charged, and there were 356 administrative revocations from the program. So those are just illustrations of the fact that the next question could probably be asked. I know we talked briefly about labs a moment ago. Operation Double Helix, you'll recall, from 2019, dealt with labs. I think it's fair and probably wise to be asking the question about referrals in that case as well. What, if anything, could be gleaned from that? Very, very important. And of course, it's timely. I will say this, that there is the HHS and the DOJ have been very interested recently and for the past year or so in becoming more consistent and formalize the way in which they interact in the False Claims Act arena. Early in detail with respect to issues that will arise as the DOJ and the client agency, so to speak, go forward in developing those cases. There's a heightened degree of interaction that will continue. It's again, just great interest, and it's very timely today that we're talking about that. So I would stand by for information regarding that. Finally, on parallel cases, Lisa, very quickly, I noticed there's a slide we're going to get to about that, and I can either wait or throw this in right now. In the parallel case context, we're all generally familiar with the civil and criminal parallel case policies that exist with varying success among the U.S. attorneys' jurisdictions around the country. You can imagine that process being designed to make sure that both sides of the house work together up until the point that it's appropriate to develop potential fraud lead cases. Imagine that if you threw in the administrative branch as well, OSIG, CPI, everyone that has an administrative tool, along with civil fraud section, along with the strike forces and those, and had everyone looking at conduct about the same time and making decisions and decisions on that going forward. So those are all, again, very high priorities within the government, things we're working on across the board, and they generally apply to all of the subjects we're talking about. So, Lisa, I will stop there and wait for an opportunity to talk a little about the pandemic whenever you think that's appropriate.
Terrific. Thank you so much, Alec. Next slide, Courtney. All right, so we just talked about the government's priorities, and they naturally tend to overlap with the related bar priorities. But Amy, fill us in on what your bar is working on and what's selling at DOJ.
Sure, thank you. It won't surprise you to hear me say that relators' priorities are what the government priorities are. We've talked about that and the kinds of cases that they have been bringing and will be bringing. Obviously, a lot of what DOJ does, they do things on their own, for sure, but a lot of what they do is based upon things that are brought to them by the whistleblowers. The government priorities matter because the goal is to get them to intervene, and also either way, you care about materiality issues. But again, we, in some sense, set the agenda by bringing credible whistleblowers to them with issues that we think matter and that will matter to the government. Initially, what we look for is, fraud that we have a credible whistleblower who oftentimes has inside knowledge. You don't have to have inside knowledge, of course, but that's helpful and something we look for. And someone who's honest and doing this for the right reasons. I think we've all heard the phrase, take the rogue to catch a rogue. And a lot of times whistleblowers sort of get a bad rap as being just disgruntled employees, who are having employment issues. And sometimes that's true, but also there are many whistleblowers that really do this for the right reasons. And so we're looking for those kinds of cases on issues that the government cares about, egregious fraud to bring forward. Oftentimes in the healthcare context, that's patient harm, because obviously the government cares about that, as they should, and as we all do. We're looking for clear violations that the government would consider to be False Claims Act violations, and that we're meeting all the elements, and making sure that there's scienter, and that it's not a mistake kind of thing, but that the companies that we're looking at, they knew about the fraud, and they decided not to do anything about it. And then, of course, that we have sufficient evidence and documents and examples. We're going to talk about later 9B and that sort of issue. You don't have to have sample claims, and it's harder to for relators in particular situations, but it's compelling to the government, and so we try to bring that information, show them how they can prove their case. And of course, damages. The government wants to go after cases where there's money. The whole point of the False Claims Act is to get taxpayer money back. And so there's got to be money involved. Certainly, there's always penalties and things like that, but there's got to be actual damages as well to make it something that the government want to spend their resources on. And the worst thing that happens in a case is you get to the end and there is no money or bankruptcy or something like that. So those are the kinds of things we're looking at. And again, the priorities are what we talked about before and the issues that the government cares about.
Next slide, please. So Brian, your client is under investigation or thinks they're under investigation. What are your priorities and the defense bar's priorities?
From an overall perspective, we're trying to clamp down on the overuse and misuse of the False Claims Act. Amy, you painted a rosy picture of some of the cases that are filed, and they meet the elements, and the relators are these wonderful white knights trying to bring justice. But a lot of cases aren't. And what I wanted to mention as some defense priorities is how we go about trying to deal with those issues. First, C2A dismissal. This has been referenced by a few different panels earlier in the program this week. The Deputy Assistant Attorney General referenced in his remarks on Wednesday that subsequent to the Granston memo, DOJ has moved to dismiss about 50 cases. And so on the one hand, you would say that's a positive. And I think DOJ has talked about that as a positive, that they're using their dismissal authority more frequently than they did in the past. But if you start to look at those numbers a little bit, of those 50 cases, 10 of those cases were all brought by the same for-profit relator entity. 12 of those cases were cases where the relator wasn't represented by counsel at all. 2 of those cases were cases where the relator had sold short the stock of the defendant. And so really, it doesn't leave a lot of cases where the government is proactively stepping in to dismiss cases that don't need to be moving forward because of the underlying merits of the action. And I think that's where C2A really starts to overlap some with Escobar. I know that some of the speakers on earlier panels talked about that if the government gets to a point where it's deciding to decline intervention in a case, that they want to be upfront with relators counsel and defense counsel at that time about the agency's views on the underlying regulations. This is incredibly important in healthcare fraud cases where you have thousands of different Medicare regulations, and you have relators bringing all sorts of QTAM cases based on violations of some of these regulations, of the importance of knowing early on in the process if the government is declining intervention in a case, are is CMS going to ultimately stand behind the theory of liability that the relator is pushing? In my experience, in a lot of cases, is that's not information that DOJ is sharing up front. And I don't know if it's necessarily that DOJ is withholding the information. I think my experience has been a lot of times by the time a line attorney reaches the point of declination, they consider their work to be for the most part done. And you have a defendant and even relators coming in and asking them to go beyond declination to say, is this a theory of liability that CMS is ultimately going to support? It would be helpful to see more of that. For me to get that information, a lot of times it's pulling teeth. It's information the government doesn't want to share until we finally get around to a 2-year request. And I think it would benefit both relators and defendants to have information in these implied certification cases based on violation of Medicare regulations. It would help us to know early on in those cases, is this a theory of liability that CMS is going to support? Otherwise, on Escobar, I think for the most part, the defense bar is pleased with the way that case law is developing. I know that the government and relators continue to push for a theory or interpretation of materiality, that something is material if it had the natural tendency or if it had the potential of influencing a reasonable person. And I think by and large that perspective is being rejected by the circuit courts, and we're pleased by that. And then if you go to the next slide, two other areas to mention is public disclosure bar and Rule 9b continue to be extremely important to defendants in declined qui tam cases. I referenced a Sixth Circuit case, mainly just because of the really broad view that the court takes in this case on the scope of the public disclosure bar. In the Heartland Hospice case, there were 3 separate qui tam cases that were filed in South Carolina relating to one specific hospice agency in South Carolina. The government declined intervention in those cases, and the relators voluntarily dismissed them. A couple of years later, a new relator filed a qui tam raising allegations not just as to the single hospice in South Carolina, but saying that the corporate parent was billing claims inappropriately at hospices around the country. The new qui tam also made allegations going years into the future, so it covered a different time period than the 3 previous qui tams. Despite that, the Sixth Circuit still held that the new qui tam was substantially similar to the actions that had been filed before, showing that courts are taking a broad view of what's considered to be substantially similar. And then on 9b, of course, I'm going to disagree with Amy about whether or not relators need to come forward with sample claims, but included 2 cases. The Banasa case was a kickback start case where the relator alleged that because all referrals from particular doctors were false, and because of the fact that the hospital in question got almost 30% of its revenues from Medicare, the relator argued that was sufficient to plead presentment in that case. That the Eighth Circuit disagreed, I think in line with a lot of circuits. And then also included the Integra Med Analytics case, which is a case brought by a professional relator that used a proprietary algorithm, whatever that is, and I would like to have one. But they used a proprietary algorithm to analyze publicly available Medicare data to allege that the defendant health system was upcoding claims. The Fifth Circuit upheld dismissal of that case on the grounds that wasn't sufficient to plead violation of the False Claims Act. Despite that outcome in the Fifth Circuit case, I think we're continuing to see increased use by relators and the government of statistical analysis in FCA cases. And then finally, separate from litigation, when defendants are reaching a point in the case that they do want to resolve the case, Alec just made mention to a million different levers and different governmental entities that potentially have interest in these cases. And for defendants, it raises the challenge of Once your client decides we don't want to litigate this anymore, we'd like to resolve this, of needing to talk not only to someone like Natalie at DOJ or Stacy at the states, but potentially having to think through other entities that may have a stake in the settlement, so that when the defendant settles, they're buying peace and not going to have to deal with the action anymore.
Thank you. Can you, Courtney, go ahead to 2 slides? All right. I want to make sure, we've only got 15 minutes left, but I really want to make sure we cover this, because objective falsity in the healthcare arena is absolutely a hot topic and something that I think we're going to see more of. I will mention that the panel had a consensus on what the priorities were going to be for each of the stakeholders, but we had a very spirited discussion about whether objective falsity actually is a thing or not. So Brian, why don't you introduce the topic, and Natalie, I'm going to ask you to weigh in after Brian presents it.
Yeah, so the question basically comes down to, can the government or the relator take a case forward based just on reasonable disagreement of physicians? If the defendant is going to put on evidence that the treating physician made a particular decision about medical necessity, is it enough to get a case to a jury if the relator or the government just brings forward their own expert who disagrees with the decision of the treating physician? The 11th Circuit has answered that question no, saying that's not enough, that you can't take a case forward unless there is some objective falsity beyond just the mere disagreement of treating professionals. The 3rd Circuit and the 9th Circuit have come out differently on that question. The AseraCare case, the court's decision was actually post-trial. The Care Alternatives case was on summary judgment. The Gardens Regional decision was on a motion to dismiss. But the 3rd Circuit and the 9th Circuit both held wrongly, in my view, that it is sufficient to take a case forward based just on the disagreement of treating professionals.
And Natalie, what's DOJ's position on objective?
Thanks. So I think there's a few points that are really important here. And the first one is one that Brian already raised, is does this get to the jury? And in my view, a juror is fully capable of evaluating all the evidence, including witness testimony, such as expert testimony, along with medical records and other potential evidence, to decide whether a medical necessity certification is true or false. So I think that cutting these claims off at the summary judgment stage really pushes against the fact that jurors often perform similar exercises in criminal healthcare fraud cases and malpractice cases, where courts regularly defer to the jury's ability to weigh the evidence and determine the credibility of witnesses. I think the other important is that, in my view, the concept of objective falsity really conflates the idea of falsity and the idea of scienter under the False Claims Act. And really, the focus should be on whether the claim was payable, and then you can move on to the inquiry as to whether there was a knowing violation of the False Claims Act.
And Stacy, go ahead, Brian. Yep.
Yeah, just to respond to both of those, I think on the first point, the problem with saying that not to just go to the jury is that the Medicare program has been set up to defer to the treating physician's decision when it's made in good faith and reasonable. And to say that the government or relator could just go out and find some minimally qualified expert who's going to disagree with the treating physician is really a watered down view of falsity. But also addressed to the second point, what I hear government lawyers, relators counsel say on panels like this is, look, what's the big deal? We still have to prove a scienter. Don't worry about falsity. We can't bring a case forward unless we prove scienter. I think the problem with that is it reminds me of horror films that we saw in the 80s when we were growing up. And it's like where the character says, hey, is it okay for me to go out to the barn to get a shovel? And they're like, yeah, don't worry about that at all. I see Scienter as basically the barn. You don't want to go to the barn. Good things aren't going to happen. Who defending an FCA case wants the case to come down to just making arguments about Scienter? Because where that's going to get you is to a place where the government regulators are going to try to introduce, a handful of emails taken perhaps out of context, out of hundreds of thousands of documents produced. Introduce some emails to say, the provider wanted to keep their referral volumes up. Match that with an expert who said that claims aren't medically necessary. Given that damages under the FCA are punitive, that's just not sufficient. So I think on my end, we're hopeful that the Supreme Court will accept cert in the care alternatives case and weigh in on this.
I would just like to add that I think Scienter is really the backstop. I don't think it's the main argument. And I think that cases aren't brought where it's just a disagreement between two physicians. And so I think that's really not the way these cases work. I mean, I think they're really important cases, and I think there was some concern when the district court decision came out that these cases may not be brought anymore. But I think the importance now, what I'm seeing and very happy about, is that I think these cases are showing that that there's more. It is really important that that when there are issues of intent being money over medicine, those kinds of cases can't be overlooked. And these cases are not just mere disagreement of physicians, even if you take what Escobar says. And I think the more recent circuit courts really address the issue in ways that make sense for False Claims Act cases.
Well, and I want to make sure Stacy gets a word in on the state point. But one other thing I think we all need to be mindful of is that under Part C, where there's already a prior authorization determination by a clinician has approved the claim before it even gets to the point of payment. And so I think as these cases move forward, there's going to be some additional discussion about exactly this issue, because you're naturally setting up a disagreement among physicians. But Stacy, how do the states view this?
Well, I think, obviously, our position is pretty aligned with the one that Natalie expressed, and that I do see Scienter. Actually, I see Scienter as a hurdle that the government is one of the hardest things, in my personal opinion, with the cases I've run. Scienter is one of the hardest things for me to be able to prove. So I don't see that as the easy part of the case. So I anticipate that we will continue to work these in Michigan, particularly following our state law, which was the point of the talking point, Lisa. So let's get to that. So the point I want to make here is that although many states' False Claims Acts dovetail pretty nicely with the Federal False Claims Act, and there are all kinds of reasons for that. Some state False Claims Acts have some differences. Michigan is one of them, but not the only one. And on this particular point, Michigan differs in that it specifically calls out and allows for False Claims Act cases to proceed based on medical necessity. Medical necessity is actually referenced in the statute, and the way that this works here is that we present expert opinion on the medical necessity of the service, and then we get to Scienter thereafter. So in the same way that Natalie had set it up, it's actually how we as a state actually work those types of cases here in Michigan. And the point is just to say this: a lot of times, these cases are worked on a national level, and the states are included, and we're named in a bunch of cases. But to the extent that the bad acts that are being alleged are specifically associated with one or two states, it behooves folks both on the relator side and on the defense, because it provides the defense cover. Some of these statutes provide the defense more cover as well. But it behooves folks to actually be paying attention to the local laws too, because it can really maybe move the case where you might have a vulnerability on the federal side and you're not on the state side. Or perhaps you've got a defense on the state side that you didn't realize that you had. So I just want to make sure that I flag the benefit of the state programs too, and the state laws.
Thank you, Stacy. And I'm going to ask Courtney, because we only have 4 minutes left, to just skip ahead to the response to the pandemic slide, because it is a healthcare panel. The pandemic is a healthcare issue, and I want to pose this to the entire panel, and anybody who wants to start can. Can the failure to follow a health order that contributes to the infection of government healthcare beneficiaries give rise to False Claims Act liability, and what are we going to see in the future? Natalie, maybe you want to start? I think Natalie's frozen. Alec, for the
sorry, I was trying to unmute.
Sorry.
Yeah, why don't I let Alec start?
Go for it, Alec.
Sure. Thanks, Lisa. Well, I'm not going to answer the question as posed, but I will say this: there, as you know, in order to prevent it and spread and protect access, there were some 400 plus waivers and flexibilities put into place to respond to the pandemic. Many of those are, potentially have opened the doors to some misbehavior. The group should know, and I think it is known, that we're making a waiver by waiver, flexibility by flexibility analysis of those to determine what, if any, particular vulnerabilities they may have opened up to fraud or abuse. We're undertaking that work now in connection with and coordination with all of the law enforcement partners that we have, including the civil fraud section and others. So I think that what I would say here is that the answer is always potentially yes, it can, if the elements are lined up and the policies are concerning enough that have been violated. I think the specifics of that remain to be seen, but I'll give it to Natalie to
Yeah, and I think I'm going to follow Alec's lead here and not exactly answering the question that's posed, because I do think it's very fact specific. But in various periods where the government has expanded a program or the government has had a need for a significant outpour of dollars in a short period of time, we often see schemes that follow, and we are already starting to see work around the pandemic. And I do think that this will be something that continues for the next few years. It often takes some time for whistleblowers to bring suits to us. So I think, we often lag a little bit behind the initial event of providing the waivers or giving out the money. But this is going to be, I think, a really interesting area for the next couple of years.
And Amy, I can assume that this is something you'll be following as well.
For sure. It's interesting, a lot of people have slowed down during COVID, and we have a lot of whistleblowers coming to us with these types of issues and all sorts of COVID-related fraud. So I think it's on the next panel, we'll be talking a lot more about what it's resulted in.
And Brian, maybe you'll take on the question, because I think I know your answer, but go for it.
Yeah, I think the answer is we certainly hope not. I think that so many different healthcare providers have been dealing and working through such challenging circumstances over the past year, doing the best they can in very, very difficult circumstances. And no doubt actions are going to be brought in the future. And I think we hope that conduct is going to be viewed based on whether providers were doing what they could, what was appropriate under the circumstances.
Yep, it is after all a fraud statute. I want to thank you guys very, very, very much for attending, and also for the spirited discussions we had in preparing for this panel today. That is all the time we have, but I would like everybody else to please log into the next sessions. You'll note that they are 2 sessions simultaneously held. One is the procurement fraud session, and the other is the state FCA roundtable. If you pick one and you're looking for CLE credit, you'll want to stay in that session, because if you toggle back and forth, you end up not being eligible for the credit. The materials are, of course, available through the lobby if you want and would like to know more about both. On behalf of the American Bar Association and the ABA Criminal Justice section, I'm Lisa Noller, and thank you on behalf of the panel and also for the ABA.
Thank you, Lisa. Thank you, everyone.
Thank you.
Thank you.